Good morning to one and all present here today. I, 𝗬𝗚𝗟𝗏, on behalf of the Moot Court Society, take immense pleasure in welcoming you all to today's training session for the second PGCL SAARC International Moot Court Competition 2022, hosted by the 𝗬𝗏𝗏 Pravin Gandhi College of Law, Mumbai. It is my great pleasure to welcome our esteemed speaker for today, Professor 𝗬𝗏𝗏𝗏𝗏𝗏. Ma'am is a lecturer of taxation law and an assistant dean at the Office of the Academic Affairs graduate program at the Jindal Global Law School, India. Ma'am pursued her graduate studies in law at the Mumbai University and then read her LLM at Queen Mary University of London. She has practiced as an indirect tax attorney before various high courts and the Supreme Court of India. She has also served as a senior associate at 𝗚𝗏𝗏𝗏 and Associates, where she was involved in tax litigation and drafting commercial contracts. It is an absolute honor to have you here with us today. I would now like to call upon 𝗬𝗏𝗏𝗏𝗏𝗏 ma'am to begin with the session and address the participants. Lastly, the participants are required to add any of the questions in the chat box or the WhatsApp group, and they will be addressed at the end of the session. Thank you.
Right. Thanks, 𝗬𝗚𝗏𝗏𝗏𝗏, and thank you so much, ma'am. Primarily, it's an absolute honor to have seen you today on screen.
Thank you so much.
Four and a half years now.
Yeah.
More than that, 5 years, 2017. I passed out in 2017 from the law school. So yeah, it's incredibly a pleasure to come back to the alma mater and definitely to the Moot Court Society, with whom we were very, very actively involved during our tenure. So thank you so much for having me.
Thank you so much, 𝗬𝗏𝗏𝗏𝗏. Please continue.
Ji. All right. So without taking more time, I would like to primarily start my session today, which is titled The Art of Mooting. Right. Am I required to keep my camera on throughout the duration of the session? Because it's going to be me staring at myself on the screen and I'm just going to be losing track of the points that I'm going to make. Is that all right if I go off the cam? If none of the other participants are going to turn on their cam?
If the participants can switch on their camera, or else, ma'am, if you're at your convenience, if you want, I can keep my camera on, or if you want, you can switch off your camera.
I want to be off the cam if none of the others are turning it on.
All okay, ma'am. Okay, ma'am. Thank you.
Yeah. Right. So, our prime topic for which we've gathered here today is the art of mooting, which inter alia would definitely involve within its purview the art of arguments, right? And this, according to me, is rather the most significant and the most pivotal aspect of a lawyer's life. So this session's not primarily going to be a monologue, a discourse, and would rather want you all to put in, I would want you all to put in your points, your perspective in the course of the session so that we could make it as interactive as possible. And yes, definitely towards the end of the session, we would definitely leave the dais open for any questions that may come up in the course of the session, right? So they always say that a man should be true to his words. However, for a lawyer, it's rather important that his words rather sound true, and this rather differentiates a lawyer from the rest. Right? So it's not always that a lawyer should defend what is the right, but as young lawyers, you all should note that it's not the job of the lawyer to sit in judgment whether or not a particular side that he or she is defending is the right or the wrong, but rather defend his client to the fullest of their potential to make sure, or rather to ensure, that justice is rather attained, right? And that's where the key qualities of a lawyer would play a very crucial role, right? So, and in my opinion, the first step towards this journey of becoming a good lawyer, a good practitioner, a good pleader begins right from your formative stages during your law school in the form of moot courts, right? Mooting offers you an excellent opportunity to develop your skills, to make sure that you hone yourself as a budding lawyer, not only your oral argumentative skills, but also definitely your drafting skills. And in my opinion, your moot court experience plays a very crucial role even alongside your internship experience onto your CV in order to help your prospective employers to select you as a prospective candidate or a prospective employee at their firm, right? So it's very crucial that the art of mooting, as the topic that we have at hand today, must be dissected into various aspects, right? I'll be covering the crucial importance of the knowledge of facts, how relevant it is to be well versed with your facts of the case, to necessarily present your issues in an articulate manner so that the bench is very well aware as to what segments of the case would you be presenting in your speech. Going further, how would you apply the law at hand to these facts, along with the help of certain important citations, authorities, important principles, definitely in context to the case that you have at hand, the Janakland Constitution's case. Definitely, how would you apply your international treaties and conventions, their binding force, if any, right? What would be your skills, additional skills, your persuasive skills that would be crucial in developing your course of arguments? Further, making sure that in the process of putting forth your point, you definitely maintain a decorum in the courtroom, albeit virtually, as I understand that the competition would be held virtually given the current set of circumstances. Further, obviously, manage your time. Time management is again going to be one very crucial aspect that I'll be touching upon in the course of my session today. Lastly, any basic body language etiquettes, courtroom etiquettes, and how would you conclude your arguments with the help of a pleading prayer so that the court or the bench is necessarily convinced as to what were the issues and what are you finally pleading as a relief from the bench. All right, so that's going to be the structure and the flow at which I would necessarily be structuring my session today, right? So when we talk about the first aspect, knowledge of facts, right? Anyone, can anyone tell me right here? I see some participants present here on a Sunday morning. Thank you all for joining in, right? So what would be the relevance of your facts and how a factual circumstance can make or break your case? Anyone aware of a situation, would like to share an anecdote, would like to contribute? It'll be great, definitely. I wouldn't want this to be a complete monologue at my end. That's how I would genuinely appreciate if there are some comments from you students present here. Yes? What do you think? I don't mind you, putting your hand up and responding, or maybe dropping your comments in the chat box. Yep, no response. Good morning, PGCL, and all the participants participating in the second International SAARC Moot competition. No response. Not done. All right, guys, facts play such a crucial role that unless you are having a complete knowledge, a complete and true knowledge of your facts, of the proposition in detail, you would not be able to, defend your case. You must make sure that you're not only acquainted with the facts of your own, of the side that you are defending, but definitely of the opponent side as well, because as I understand, there would be several rounds in the moot court competition, and at every round you may be having a different side to represent. So understand that knowing these facts primarily is the first step. Second, using these facts accurately is a crucial step. Let me give you an example. Okay, if the facts of the proposition hypothetically state that there were certain right hand fingerprints that were recovered from a weapon at a stabbing site of the accused, right? And if the facts state that the accused was a left-handed person, right, you think that you would be able to win your case on this particular point single-handedly without even applying any legal provision at hand. You just need to be very mindful, have that presence of mind, and state that, oh, the facts definitely say that XYZ person, the accused, was a left-handed person, and the weapon which has been recovered has the fingerprints of the right hand. And being able to stab the person with another opposite hand with the same amount of force, same amount of gravity would not be definitely possible, or definitely account to a lethal kind of a situation. Right? So merely on the points of your usage of your facts accurately and having that presence of mind as to where to apply which fact of the case can definitely make or break your case. Be very thorough with the timelines provided in the proposition. The timelines can help you determine whether or not a particular point, would it come within the purview of that particular law, or would it be beyond the operation or ambit or effect of the law, right? So it's very crucial to not only be well versed with your facts, be it however, minute as they may be to you. You never know how those minute facts may actually help up build a circumstantial evidence in your favor. Right? So facts and their knowledge and their use plays a very, very crucial role. Any questions on this first very little segment that I spoke about? I would rather want to have questions even during the session so that, again, an interactive session. Yep. Anyone with any questions or comments? Has someone unmuted themselves? Would you want to go on mute? Yeah, thank you. Yes, do we have any questions? Are we good?
Ma'am, we do not have any questions. I think you can proceed.
All right.
Thank you.
Participants, fab, usage of those reaction emoticons onto the Teams platform. If you do not have any questions, just a thumbs up would be a good signal for me to know that I may proceed. All right, please do so. Great. So going forward, the next and the most important segment that I would like to talk about would be your applying this knowledge of these facts along with the legal provision, right? So please be well versed with each and every provision that has been provided in the moot court preposition, firstly. Second, read thoroughly the entire statute, however time consuming it may be, right? Because you never know as to which question comes your way in the courtroom. You would not want to be oblivious in front of the bench, right? Definitely you could refer to your legal statutes and your provisions and your international treaties at hand, but it's always advisable to read the law in toto, in entirety, so that you are able to understand the context, the legislative intent of every provision, and the repercussion that it may eventually have onto your hypothetical moot problem, right? So apply this law very accurately. Now, one very important aspect that I would like to share from my personal experience is that whenever you apply the law, your law should not be just merely incidental or tangential or just remotely connected to your hypothetical. Absolutely no, that's a big red flag. Always make sure that the law and the propositions that you would be definitely highlighting in the course of your oral arguments as well as in your written memorandum are all strongly and squarely connected with the facts of the case. at no point remotely connected provisions be completely what do you call completely sufficient enough to make sure that you would be able to win your case in your favor, right? Tangential arguments only should be advanced once you have made your prime points on merits. All right, definitely towards the fag end of the session, I would be taking you through how do you structure your entire argument, but make a note of these most important points, and I understand that these points are also your assessment criteria on the basis of 100 marks of your oral argument. So that's how I'm trying to dissect every assessment criteria for you primarily, and then we would go on to the second segment of structuring our argument. All right, any questions on to the second point of application of the law to the facts? Are we good? Yep, may I head? Wonderful, thank you.
Yes.
Great. Now comes the third important aspect, and I would request you all, if I may please call you students, right? Please make a note that the order in which I am proceeding with my pointers here, first being the facts, second being the legal provisions, third being ancillary and allied authorities, precedents, and case laws, which are very crucial to support your arguments and to back your legal contentions. Okay, this is rather the order of preference even during your argument. So remember that first state the facts, always then connect the allied law with it, then cite your provisions, cite your authorities, cite your precedents in order to be able to necessarily make sure that you are following a structured pattern, right? And as we talk, there is a question by Ms. Anushka. She says, in case there is an argument that we are unable to connect with the law directly, how should one go about with it? Anushka, would you want to give me an example as to what you're trying to necessarily state? Why would you want to make an argument which is not necessarily directly connected with the law at hand? Would that help you make your case in the first place? Yep, would you want to unmute yourself, Anushka? Come on, we are all learning here.
Yes, so my question was like, in case there's a logically factual argument that does make sense, but somehow you're like having a difficulty to connect it with the law. So,
right.
So then how do you go about it?
If you are making an argument, exactly, right? So your argument can win on different points. It can win merely on points of fact as well. Do not always be mistaken enough, Anushka, that you would win your argument only if you have connected with an allied law. Absolutely not. Right? You only if you are able to connect your arguments, even with the facts, it can still be a winning argument. It's not always necessary that it should squarely necessarily fall within a provision. And as I understand, it's a criminal matter before the ICC, right? As a moot proposition, if I'm not wrong, right? So you are able to definitely, your factual circumstances, prime importance. Then comes your legal provisions, and obviously you can't just base your entire arguments of all the three issues merely on facts. That also is a red flag, Anushka. So remember, not just facts, not just law, but a combination of facts, law, backed by your case laws, backed by your statutes, backed by your international treaties, would help you holistically win your case. Okay, Anushka, so if you're not finding a loophole in the law, find one in the treaties. Find an allied case law to help you back that particular proposition that you're making on points of fact. All right? Am I making myself clearer, Anushka?
Yes, I got it. Thank you.
Wonderful. All the best. Great. May I proceed? Yes, great. Good to see some faces at least on the camera. It gives me like a smaller boost, right? Hi, Siddhi, Aiden, Devanshi, and Vedhi. Great, right. So going on to my next point, right? Are we all clear with the application of law to the facts? The first 2 points are clearer. Coming on to the third aspect, that's the citations, authorities, and your allied legal principles apart from the principal primary substantial statute, right? So when you talk about your ancillary cases, Afrin, refrain from stating anything completely new, completely alien from what's been stated in your memorandum. Okay, let me be as honest as I can. Okay, because not long ago I was on the other side as well, but as honest as I would want to be, Afrin, you may not want to fool the judges, right? If you have stated an XYZ proposition in your memorial, and if you are stating an ABC proposition in your written arguments, and if in the process of skimming through your memorials, if the judge comes, points that particular point out, you are going to be in trouble, and your credibility of your arguments would completely fall down, right? So if there is a connected point in connection, in a logical extension to the point that you have stated in your memorial, and if you'd like to expand on it, definitely you may do that. But do not completely digress from the points that have been mentioned in the memorial. Making a newer argument on a completely newer premise and proposition, completely different from what's in the memorial, may be a troublesome issue. So always talk in a logical extension to the memorial. You may not stick verbatim to the memorial, and on that point, please refrain from reading out your memorials directly in the courtroom, right? I have seen lawyers today, practicing lawyers, do that. They go open their affidavits, open their written briefs, and read it out. The judge is not interested in helping you, or rather to see your reading skills. No, be concise, be precise, be short, be brief in your arguments. If possible, prepare a synopsis. I do not know whether the competition rules have prescribed preparation of synopsis, but it's always advisable that you have a handy summary of your arguments, a handy summary of all the points, including the facts, along with the page number, relevant page number onto your memorial, so that you can direct your court, direct the judge to that respective argument in the memorial. So Afrin, rather than digressing from your memorial, why don't you, have points stated in conjunction to the memorial and take the judge back to your memorial, which says that, okay, what you're saying today is definitely even presented in your written submissions. That makes your case stronger, right? Afrin, are we clear with your question? I hope I've tried to do a little justice to your question. Any further follow-up questions on that? I'd be happy to take that up. Yeah, you may please.
Thank you, ma'am.
Yeah, sure. Right, you may definitely feel free to, add those in the chat box. So yes, so I was talking about applying the authorities and citations. One very important point that I feel is, please follow up on all the cases that you have cited in the course of your memorandum preparation till the final date of the argument, whether or not there have been any developments in those cases, whether those cases have been overruled, whether there have been any allied judgments of allied courts or concurrent authorities or even higher authorities to back your arguments, or if there are any differentiating opinions, please make a note of those as well. Right? Because, a lot of times students may have prepared their memorials 2-3 months in advance, and the arguments, the competitions happening quite later, right? And in that little span of time, you do not know how the case may have progressed. So keep a tab at least of the most landmark cases that you are definitely citing and relying on to your arguments, so that you do not want to be citing any case which is no more having a binding force of law, may have been rather overruled, right, with a court of the concurrent or a higher jurisdiction. So it's very crucial to follow the developments of that particular case through the course of your competition, and do not just restrict your readings only up to the form. only up to the point of memorandum drafting, right? This is one very typical error that I've seen in law students in the course of their moots. They do most of their research only till the point of the memorandum submissions, and beyond that, it's merely building onto the arguments that have been stated in the memo. No, your research has to be an ongoing process. And Afreen, again, a point connected to your question: what if there is a development in the law in the course of these 2-3 months when your memorandum has been submitted and your arguments come in stage? Definitely point that out to the court, right? That's when your responsibility as a lawyer, who is a lawyer, an officer of the court, right? Helping the court to arrive at justice. So if there are any changes, any amends in the law, any newer developments in the law, any newer cases that have come in play, any newer treaties that may have been ratified or executed in that little duration until your memorandum submission and your final competition, it is your duty to make sure that you tender these points into your in the courtroom. Make sure that these newer points definitely come in play and state the reason, right? State that this was a logistical aspect that is involved. If possible, tender evidences with the permission of the bench, along with not just apprising your bench, but also your opposition team, right? At no point would you keep your opposition team in oblivion. If you are citing a newer case that has developed in the newer span of time, make sure that you tender copies to the bench as well as to your opposition. I know that this is going to be a little bit of a difficulty in a virtual situation. That's where ask the permission of the bench if you could share your screen, right? And take the bench with the relevant developments in the law, right? I'm sure the opposition would then to be able to comprehend this, right? Are we good? May I head on to the next point? Yep, and any further questions onto this? I'd be more than happy to take them up. I'm so sorry, may I just grab a glass of water? Just a moment, please. Right, going forward to your next point being your, yes, definitely, Afreen. Now, obviously, all the regulations subject to the approval of the organizing committee. I definitely may not be the final authority onto these logistical aspects, but if you could procure a permission of the organizing committee along with the bench, and make sure that you're completely transparent in your arguments, I'm sure this shouldn't be an issue, right? Because you're definitely going to be making a legitimate point, and it's not a frivolous argument, not a frivolous point that you'll be making forth. So I don't think that should be an outrageous issue, in my opinion, right? Okay.
Thank you, ma'am.
If any of the members of the organizing committee would like to confirm that for Afreen and for the rest of the participants, it'll be better as well. So you could, make a note as well, the Moot Court Society. Right. So going forward, the next point that we have is your skill of advocacy and your persuasion skills. This is where your oratory skills play a very crucial role. If you yourself are not putting forth your arguments with conviction, if you yourself have that little jitter in your voice, if you yourself have that nervousness, which is very much apparent in your face, in your body language, again, in a virtual setup, it's just a little part of your screen that's going to be visible. But if you are still extremely nervous in your demeanor and the manner in which you are putting forth your arguments, definitely it's going to not reflect really strongly for you as a speaker independently and for the rest of your team. So if you are not convinced with an argument, I would advise you dig deeper into the law. Dig deeper into your allied provisions, dig deeper with your research, and make sure that you make your points so strong enough, especially on points of merit, especially on points of elements and criteria of the crimes that have been put forth in your moot proposition, right? It's Article 6 and Article 7 of the Rome Statute, if I'm not wrong. So dig deeper into the ingredients of these crimes. Make sure that you have allied cases in your support so that you're able to prove your side, right? If there is no conviction and no persuasion in your style of arguing, let alone the court, your team would lose interest, your team would lose faith in you. You wouldn't want that, right? So it's always advisable that you be a stronger, a confident speaker. You need not be having a flawless oratory English. You need not be using extremely difficult terminologies. Your arguments could be in simple, shorter sentences, layman's language, doesn't matter. So long as it's relevant, so long as you are being crisp. Please manage your time well. When you come to the dais, when you unmute yourself, make sure that you firstly, lay down which issues would you be dealing as a speaker, right? You do not want to be haywire in the process of arguing. You do not want to talk about the ingredients of Article 7 while you're proving the ingredients of one crime while you're talking a jurisdictional issue, right? Under Article 17, right? So always make sure that you are making very clear to the bench that, okay, I as a speaker 1 would be dealing only with so and so article and this jurisdictional issue, so that the bench is also clear and they would not ask you questions beyond the scope of your arguments. Right? If you are yourself all haywire and all haphazard in the process of arguing, definitely the bench is also going to keep on grilling you with as many questions as possible. You wouldn't want that situation, right? That would again cause a nervous breakdown on screen. You can't afford that. So the best manner is to make sure that you take the judge through your arguments by telling them, okay, your lordships, your ladyships, I would be, or however you would like to address them as per the decorum of the ICC. Make sure that you take them through, okay, I am going to be dealing only with this segment. My co-speakers would be dealing with XYZ segments, so that the judges are respectively posing questions only with respect to that segment to you, so that's where you will be able to ensure that you are able to answer your questions to the best of your abilities on segments that you're thoroughly prepared with, right? If you're talking about the entire matter in your first issue, obviously the judge is going to be asking you questions on the entire matter in your first issue, right? So as we speak, there's another question. In case we don't know the question don't know the answer to the question asked by the bench, what should our response be and how should we go about it? It's very well possible that you may not be able to know all the answers, right? That's where your teammates have to be extremely alert while you are arguing. So when one person's arguing, the rest of the teammates must be making notes of the questions and also making their answers even while the speaker is trying to answer them, right? So in case the speaker is stuck somewhere, the teammates may ask the permission of the bench. Do not randomly give chits, I'm sure because it's a virtual setup, you can't just pass chits on, but do not randomly write hints even in the chat box, right, for your teammates without the permission of the bench. The speaker must procure the permission of the bench that can we discuss this matter internally towards the fag end and get back to the bench with that particular query. That's one. And if it is going to be dealt with in the due course of the arguments by some forthcoming speaker, you could definitely make a point there that definitely, with all due respect to the bench, that this matter would be dealt in the prospective course of arguments, and your arguments are merely restricted to these points, right? Do not completely disregard the question, okay? Even if it might be eating onto your time, hold up, okay? Be patient. Answer that question. If you do not know the answer, say that we will discuss internally and get back to you. Refer to notes. It's all right. say that my co-speaker would be dealing with this issue if you are completely blank about that issue, right? But do not completely say, oh, I do not know, and just carry on with your arguments. That will again show a very big disrespect to the bench, and that's going to be a point of, negative marking. You wouldn't want to do that, right? As we speak, 𝗬𝗍𝗍𝗍, I hope that answers your question, right? Pushpam has a query. Ma'am, if the speakers don't know the answer, but the researcher knows, can he or she ask the bench to deal with the same? Again, depending on the competition's rules and regulations, right? Whether the competition is permitting the speaker to be, to the researcher to be actively a participant in the course of your oral arguments, then you can. So I'm not very well versed with each and every regulation of this particular competition. Again, I feel the organizers are in the best place to answer this question, whether the researcher can be involved completely in the due course of the oral arguments. I think if the Moot Court Society people present in here could answer Pushpam's query, it'll be better than me giving in some information which may not be in your benefit. Natisha, would you want to come in, beta?
Yes, ma'am. Ma'am, if the bench or the judges permit the researcher to speak, then definitely the researcher can step in. Until then, the researcher can just help the speaker through the chats or other mediums.
Perfect. So Pushpam, that answers your query. The organizers do not have any specific bar. It is only with the due consent of the bench. Okay, can you proceed? So, but as apart from that, definitely the researcher can help in an active collaboration for the answers of the bench, right? Again, please be thorough with your segments, right? If there are a lot of assistances coming in the chat box, that also is a point. If I am sitting as a judge and if I see that the speaker is flustered and is completely focusing onto the body language and, prompting by their respective teammates, it is going to lead to a really not so awesome, feedback for that particular speaker in my mind. I'm going to definitely say that, all right, the speaker was not very well prepared. So it's advisable that you try to single-handedly, while you are speaking, hold the ground as much as possible. Okay, only when it's a dire situation that you genuinely need help would you go on to your teammates. Have some presence of mind. You have researched for this mood problem for minimum 3 months at least, right? So you're not completely oblivious of the situation. You're not completely oblivious of the facts. You're not completely oblivious of the law. So try to take a moment. Firstly, attempt it on your own before you seek all your external phone a friend helps. All right, that's my first important thing. Secondly, avoid being on your phone. I know as much as possible it may be, in a virtual setup, none of the organizers are going to come over to your place and grab your phone away, right? But you being constantly texting, constantly looking down onto your screen and, texting your friends is not going to give a very good, decorum out into the courtroom. So make sure that though it's a virtual setup, though onto the screen, you are always maintaining an eye contact with the judge, right? When you are talking about your persuasive skills, your advocacy skills, your body language plays a very crucial role. If you are looking down onto your screen, onto your notes and talking, the judge is also going to lose interest completely. So make sure that you are not flustered. That's my, that's the crux of the answer, Pushpam. I hope this long drawn answer gives you some little points and takeaways for sure, right? Are we good, Pushpam? May I proceed forward to Afreen's question? Right. Yeah. Ma'am, if it's not a new information, but more like a case of precedent that was not included, can we cite? Right. I told you, right, Afreen? I think in earlier point while I was explaining you that if there is a newer development in the law, you must include it. But also make sure that you take the judges and your opposition through this newer development completely, right? You cannot You cannot just tender that information to the judges and keep your opposition in oblivion. That would also lead to a negative marking, right? So make sure that if it's a newer point, you make a mention of it. But respected bench, there has been a newer development in the law in the due course of the time from the memorandum submission until now. This is how relevant it is, and I would like to seek your permission to state it right now. Then go ahead and state it, and then, you know, necessarily incorporate in the form of your arguments. All right, but it's crucial that you mention that this is a development. All right, Afreen, are we good? Any further points? May I proceed? Okay, so Afreen's not responded. I hope you're good. So I'm going to proceed forward. Going forward to my fifth segment, that's your language and style, and I did ended up touching a little bit onto this while I was also talking on the advocacy bit. As I say, your language needs to be extremely crisp. If you are formulating longer sentences with complete legal jargon, which is difficult for a person to grasp, it's going to be difficult, right? You need to understand that your judges may be senior people who may be slightly not super well versed with even a technological setup. So you must be patient. You must not let your aggression come onto your, onto your demeanor. You must make sure that your arguments are concise, right? Always have that synopsis ready, because at any time your judge may ask you to cut short your arguments and go on to the concluding point, right? And when this is happening, you surely do not want to again be flustered. Oh, what do I say now, right? So I do not want you all to mug up your arguments. It's not a rote learning competition, okay? It is being extremely well versed with what's going to be stated. Be thorough with your cases in support of every point, so that if you're asked to wrap up your arguments in 2 minutes, you're able to state the crux as crisply as possible, right? So that you're not missing out on your most important points. Your next speaker is not troubled and is not flustered due to your lack of, time management. You make sure that all the points that you had to cover, do justice to that in the designated time to yourself, so that the next speaker is not flustered with that responsibility. Because understand, the third speaker plays a very crucial role to tie all the arguments of the speakers, right? So you do not want to completely pressurize your following speakers owing to your lack of presentation, persuasion, and time management. So that's again a very important role in my opinion. Please make sure that you have a summary of your arguments so that you can be asked anytime to cut short your arguments and you still are able to hold ground, right? Lastly, your etiquettes, okay? Please bow down to the judge even in a virtual setup. Do not log out of the competition until and unless the judges have logged out. That signifies that the bench has risen and that's how you have come out of the courtroom, right? It's a virtual setup. We get it. You cannot stand up and you can't, necessarily pay your respects, but please be as polite as possible. Okay, raise your hand. If the judge is talking, you would beg to differ from the judge. Make sure that you pay heed to the points that the judge has made in your aspects of courtroom etiquette. You do not completely disregard it. Oh no, but sir, I do not agree. No, do not make such statements. But sir, you are wrong. No, do not make such statements. Okay, you know deep down that the judge may be wrong, but you can't categorically make such statements. You would have to say, I definitely respect the views of the bench, but I would beg to differ. Right? I would like to add an allied point to it. I would like to add a contrary point of view. Just be very polite, very formal in your conversation. When I was a first-year student of law, my senior, my mentor told me, when I was a very flustered student going for my first moot court competition, I recall this is back then in 2012, right? 10 years now. And my senior told me, ధ్వని, you need not worry that, the judge is right there to scare you. Think about it, that you are at a coffee table discussion, there to make a point formally, but yet making sure that you are completing that formal conversation. The moment you make it as a competition, the moment you make it like a big dragon in your mind, you're going to get lost. Think about it like a coffee table discussion, right? Think that it's relatively informal, but maintain formality in your demeanor and your arguments, right? That's where, your mindset plays a very crucial role, because if your mindset's not clear, your etiquettes are going to falter, right? You may miss out on being respectful. You may miss out on seeking permission. You may miss out on seeking consent because you are not in a good, correct mindset. So it's very crucial that you accept it, that it's going to be a very formal conversation. The judge is there to listen to me. So I'm going to make my points in front of the bench, however, very formally, right? So that's all from my side. When you come onto the basic art of mooting, I would like to take you through the very little segment of structuring your arguments, right? When you enter the courtroom, definitely firstly greet the bench, seek the permission as to what would you want to address them as, right? That's first. Once they agree to that, then you make sure that the first speaker comes in and states all the issues, right? Do not just state the first issue that you'll be dealing with. State all the issues, state the entirety of the facts, get the bench well versed with your case, and then say what you are going to be dealing with categorically. Then start your arguments, right? Do not just state a segment of the facts which is just relevant to you. Do not state just one issue which is just relevant to you and completely, again, get the judge flustered. No, you do not want to do that. State all the facts, state all the issues, then state what is your segment of argument. Go forward with your arguments. Always give anecdotes in your arguments. Take them through real life situations, give them basic and comprehensible examples so that they can also relate to this complex matter, right? Not every judge may have that particular area as their expertise altogether, right? If there are any cases that you are citing, please be well versed with those cases. Do not just cite their ratio and get done with. What if there is a relevance of that case that's been posed, right? So always be well versed with those cases. Do not base your arguments on the obiter dicta of the case. Okay, make sure that it is a ratio decidendi that you are relying on. So that's very crucial to be reading the case in toto, right? Then go on to conclude your arguments, say how that issue has been established, and finally give on to your final speaker would rather do the business of rather stating the prayer on behalf of the entire team in context of all the three issues that have been pleaded on, right? That's all from my side, and I hope I have been on time and I've been able to achieve some sort of a time management here. It's 11:55 in my watch, so 5 to 7 minutes open for question and answer. If we are okay, 𝗟𝗲𝗍𝗍 and Natisha, right? Okay, Kajol has a question. Shall we mention all the facts? No. Kajol, a summary of your facts. But the most relevant fact should come in. If you go on to read the 9-pager document, your entire time's gone in just stating the facts, Kajol. You can't afford that. But taking the judge through the most important crux of the facts again is very important. So you must not sit and verbatim read your 9 pages. No, we can't afford that at all as a team, right? So it's the role, that's where the researcher's role come in, right? They would give you a shorter, concise summary of the facts. Have that handy at all times if possible. Even tender it to the court, right? That here is a shorter summary. I'm sure there would be a synopsis, a shorter summary even in your memorandum. Take the court to that page so that they are, referring only to that document and not flipping through the pages of the moot proposition at their end. right? And if there are important aspects that you would like to highlight in the fact sheet, then you must take them through the primary document. You may please refer to XYZ paragraph on so page and highlight that. That's important. So Kajol, not all facts, only the most important facts, but in a sequential order. Okay, that's crucial. All right, great. Any further questions? Are we good? That's about it. That's all that I would like to say. Why do you refer to yourself as an agent and not counsel? Depends at which bench where you are necessarily representing yourself as, right? That's crucial. So if you are at an international court, you would definitely refer to yourself as an agent, right? Any further questions? I hope I was, yes, Yashish. Yashish, have I pronounced your name correctly?
Yes, good morning, ma'am. So I had a question. So if there is a particular section of a particular act which states certain conditions for a party to fulfill, however, the party only fulfills 2 or 3 of 5 or 6 mentioned conditions, and the rest aren't followed. So if we are siding on the party's side, and we mention only those 2 or 3 conditions that has been followed by the party, is that a valid practice, or hiding the statute or the facts would violate any?
Right. So when you are reading the provision, please pay attention to the wordings of the provision. If the provision says and, fulfill each of these conditions, condition 1 and 2 and 3 and. If the word and has been used, that means all of the conditions cumulatively and conjunctively have to be fulfilled. But if there is an either or prescribed in the provision, that means you are free to prove even one of the ingredients prescribed in that provision and you would still make out a case. So the wordings and the interpretation of the statute would play a very crucial role, in my opinion, there. Right? Read the sense of the statute, whether it prescribes you to fulfill each and every condition therein, right? Or whether your condition, that particular element would be fulfilled, even if one of those elements are fulfilled. So you need to advance your arguments in conjunction to what is the wording of the statute. All right?
Got it, ma'am. Thank you.
Right. Samiksha says, what's the structured way to answer the bench question? Samiksha, that was everything that I spoke about today. The bench's question must firstly be thanked. You must be thankful to the bench that they would want to seek or inquire into the depths of your argument. So, be much obliged for them, for the fact that they're paying heed to your arguments. That's one. Second, go on to, if there is a factual aspect that you would like to highlight while answering that question, go to the fact, state the case law supporting that particular point that you're making, if there is any, that is. If there is no case, cite a provision that may be supporting your particular argument, and then answer the question by correlating your facts to the law, and then take them through, okay, this is the answer to your question, right? Do not just give answers in the air, in thin air, without giving a context. Always give them a factual context, a legal context, and then answer the question in conjunction, holistically. All right? Any further points, guys? Wish you all the best. Ace the competition, and I'm really, really happy. Heartiest congratulations. Heartiest congratulations to the Moot Court Society, to Praveen Gandhi College of Law, my alma mater. I'm extremely, extremely honored to have been a part of this extremely grand success that we are hosting an international Moot Court competition. That's incredible. It's in the 2nd year, and I wish that it goes on for years to come, just like the NTA, the National Trial Advocacy. I'm so happy to be around my faculty, Dr. 𝗬𝗂𝗂𝗍𝗂𝗏, Dr. Suman Kalani. It's incredibly an honor to be here. Thank you so much. And if at all in the due course of my session, if I may have faltered anywhere, I would like to beg your pardon. I may definitely have gone wrong anywhere. So with all due respect to my faculty, you may please feel free to correct me wherever, in case I would have made any little unintentional errors.
It was a flawless presentation, Dhwani. So not to worry at all. Thank you so much. So very proud and happy to see you here. Thank you so much. It was absolute pleasure hearing you, and with all that I could see you like as though you're presenting the way in which that's I think a biggest learning that they have got from this entire session. Totally flawless. So thank you so much.
Thank you. It all goes back to the 8th floor of the 𝗏𝗏𝗏 College. That's where I have learned. So it's I completely owe it to the institute. Thank you. All the best. And ma'am, I would definitely, once the situation is better, would like to come to campus and pay my respects.
Please, always welcome.
All right. Thank you so much. In case there are any queries, you could reach out to me on my email ID. That's my first name, my last name @gmail.com, or onto LinkedIn. I'd be happy to guide you all. Take care.
On behalf of the Moot Court Society, I, Siddhi Mehta, would like to extend my gratitude to Ms. 𝗏𝗏𝗏𝗏 for sparing her precious time to share her valuable insights. Thank you, ma'am, for conducting the session with us and for imparting your valuable knowledge with all our participants. The session not only taught us the fundamentals of mooting, but also ignited a spark within us to further explore our skills in mooting. I'm sure our participants have benefited immensely and will be able to approach the competition with much more confidence. I would like to thank our principal and our institution of 𝗍 Praveen Gandhi College of Law for providing us with this opportunity to undertake such events and always encouraging us. Most of all, I'd like to thank our faculty in charge, Dr. 𝗬𝗂𝗂𝗏𝗏𝗏, for persistently guiding us. I would also like to thank the participants for making the session very interactive. With this, we will conclude today's session, and I thank each and every one of you once again. Before we leave, I would request ma'am for a picture.
Right, Siddhi, you could definitely take a picture, but I would request all of us to pay homage to Dr. 𝗟𝗄𝗀𝗏𝗏𝗏𝗏, because it's in his memory that this competition is being conducted, if I'm not wrong. That's what Natisha had told me. So with all due respects, may he be always proud of us, proud of the institution, proud of his students, proud of his colleagues, that we are doing so good as an institution. So all respects to late Dr. 𝗏𝗏𝗏𝗏𝗏.